Hello, everyone. Welcome to the U.S. Immigration News. USCIS announced 5 major updates that could significantly impact how people apply for green cards, temporary work visas, and other immigration benefits. These changes include revised filing procedures, stricter documentation rules, an updated gender policy, and tighter oversight on work visa quotas. Whether you're applying for a green card, sponsoring a family member, or planning to work in the US, understanding these updates is essential. If you're finding this information helpful, please hit the bell icon, like this video, and subscribe to the US Immigration News channel so you never miss an important update. Now let's get into the video. Rule number 1. Updated form additions and stricter filing procedures. One of the most overlooked causes of application rejection is using the wrong version of a USCIS form. As of May 1st, 2025, several of the most commonly filed immigration forms have been updated to new additions. For instance, if you're filing Form I-485, the adjustment of status application for green cards, you now must use the Year 1 2025 edition. The same rule applies to Form I-129F, which is used for fiancé visa applications. Submitting an older edition, even if just one page is outdated, will lead to a full rejection. Form I-130, used to sponsor a relative, still uses the Year 4 Row 1 Touch and 24 edition, but it has been revised to include stricter anti-fraud warnings and a new section that clarifies processing preferences, like whether you want the case handled by a U.S. consulate or processed within the USCIS, now also requires that each application include a separate payment. Previously, some applicants were allowed to combine filing fees using a single check or money order. That is no longer permitted. Every form you submit must have its own individual payment, or your entire packet will be rejected. If you're filing for adjustment of status, you are also now required to submit Form I-693, the medical examination form, at the same time as your main green card application. This is a departure from earlier guidance where you could submit the I-693 later. On a positive note, COVID-19 vaccination is no longer a required part of the medical examination. Lastly, many USCIS forms can now be submitted online, and the agency strongly recommends that applicants use digital uploads whenever available. This shift is designed to reduce errors, cut down on delays caused by mail delivery issues, and help USCIS process cases more efficiently. In summary, you must now be more careful than ever. Double-check your form additions, separate your payments, upload digitally when possible, and include all required documents up front. Rule number 2, USCIS can now refer more cases for deportation. Here's a major enforcement update that every applicant should know. USCIS now has expanded authority to issue NTAs, notices to appear, which begin the process of removal or deportation. Previously, if USCIS denied your application due to ineligibility or missing information, they might simply close your case. Now, if they discover even small discrepancies, prior immigration violations, or any suspicion of misrepresentation, they can immediately refer you to immigration court. This doesn't just apply to people with criminal histories or clear fraud. Even honest applicants who make paperwork mistakes, fail to disclose something in their past, or submit incomplete information may be placed into removal proceedings. For example, someone applying for a green card might be denied due to a misunderstanding about their prior visa status. Under this new rule, instead of just denying the green card, USCIS could issue a notice to appear and refer the individual to immigration court. This change is already having ripple effects across the immigration community. It puts added pressure on applicants to submit accurate, fully documented, and well-reviewed applications, because even small mistakes may now trigger serious consequences. If you're unsure about your eligibility, especially if you've had visa overstays, misstatements on past applications, or complex history, speak with an immigration attorney before filing anything. Rule number 3. Stricter marriage green card requirements. In May 2025, USCIS raised the bar significantly for marriage-based green card applicants. While the requirement to prove that a marriage is genuine has always existed, the level of scrutiny has now increased dramatically. Couples applying for a green card must now provide a much more extensive and detailed collection of documents to demonstrate that their relationship is authentic. This includes showing strong financial ties, such as shared bank accounts and joint tax returns, along with clear evidence of living together, like a lease or mortgage with both names and bills sent to the same household. Personal evidence, such as travel records, shared expenses, family photographs, and letters or affidavits from close friends and relatives attesting to the relationship, are now considered essential, not optional. In addition to this, USCIS has made in-person interviews virtually mandatory, even for couples who have been married for many years or have children together. These interviews are being conducted with a heightened level of scrutiny. Officers are now trained to look for inconsistencies in answers, observe body language, and ask more probing questions about day-to-day life, shared routines, and future plans as a couple. Applicants from countries with a history of high denial rates, or those with previous immigration complications like visa overstays or earlier denials, may experience even closer examination. The interviews are longer, the questions more specific, and the evidence more closely reviewed. The message from USCIS is clear. The only green card approvals they will issue are for legitimate, bona fide marriages. If you're applying, it is now more important than ever to be fully prepared, not just with paperwork, but with a consistent, well-documented history that clearly shows your relationship is real. If you're unsure about any part of your application, getting legal guidance could make all the difference. Rule number 4. USCIS will only recognize 2 biological sexes on forms. This rule is creating a lot of conversation. As of April 2nd, 2025, USCIS has updated its policy manual to formally recognize only 2 sexes, male and female, based on the sex listed on a person's birth certificate at or near the time of birth. If your gender identity does not match your listed birth sex, USCIS will use what it calls secondary evidence to determine how to process your documents. However, the agency will not leave the gender field blank or include non-binary identifiers like X. Applicants who identify as transgender or non-binary may face longer processing times, additional documentation requests, or delays if their documents don't align with this new policy. While USCIS has clarified that applications will not be denied solely based on gender markers, the updated rule means you must now be extra prepared to submit supporting evidence if your identity does not conform to traditional markers. This change applies to all pending or new benefit applications filed on or after April 2nd, 2025. Rule number 5, H-2B and H-1B visa caps are already filling. Let's talk about temporary worker visas, which have also seen big changes this month. For the H-2B program, used for non-agricultural seasonal workers, USCIS announced that the extra 19,000 returning worker visas for early fiscal year 2025 are already gone. The cap has been reached. That means no more H-2B applications will be accepted under that allocation. If you're an employer or applicant, you'll need to wait for the next window or consider another visa pathway. For the H-1B program, which covers high-skilled workers like engineers, tech professionals, and researchers, USCIS has completed the lottery selection for fiscal year 2026. If your registration was selected, it's now time to file your full petition during the designated filing window. Miss that window, and you'll lose your chance. The takeaway? Whether it's H-1B or H-2B, the demand far exceeds supply. Filing early, filing accurately, and staying updated with official announcements is critical. That's all we have for this bulletin. The U.S. immigration system is changing rapidly, and staying informed is your best protection. Whether you're applying for a family-based green card, a work visa, or any benefit in between, small mistakes now come with much bigger risks. The U.S. Immigration News Channel is here to guide you through every update. We cover visitor visas like B1 and B2, work visas including L1A, L1B, and H-1B, green cards under EB1 to EB5, family-sponsored visas, and more. If you haven't already, please subscribe to the U.S. Immigration News Channel so you don't miss the information that could protect your status. Thank you for watching, and we'll see you in the next video.